bit by bit, the law is catching up. So you simply provide funding for a documentary. Documentary filmmakers will tell you that they have a First Amendment right. The right of publicity does not impinge on news reporting and history and documentary. But in the case of Facenda versus NFL Films, the documentary that NFL financed was a documentary about the making of the Madden '06 game. And Facenda is the voiceover from NFL Films. You all know that voice? It was a cold, blustery day in Green Bay when the Packers took the field. Well, a little clip of old footage showed up in the documentary, resulting in a determination that that documentary was advertising. Didn't help that there was a countdown in the documentary to when the game would be available. And the court held that the whole documentary was advertising and therefore a right of publicity claim for the use of Facenda's voice, which NFL had the right to use in its documentaries, in its presentation of football games, but not in advertising. And so, as the media are so kind to provide us with all of these opportunities to trade on content, and as we and our marketing people look to take advantage of that, there is a big problem. I'm sure we will hear more about the CDA and the DMCA, the protections for ISPs, the DMCA on copyright, the CDA on claims for defamation, and arguably right of publicity. But let me just point out that the courts are divided, and in the really first case, district court case in Wisconsin, the Beverly Stayart case, the court declined to keep jurisdiction over the state law claim, but suggested that while a right of publicity is an intellectual property and therefore may be barred by CDA, which protects ISPs against private tort claims, the court suggested that the privacy claim, the commercial appropriation claim, which is a personal claim, the right to be left alone, if it's not an intellectual property claim, is not barred. So the door is open for right of publicity claims even against ISPs like Facebook, even without going to the marketing side of Facebook. Now, adjacencies are when the marketing people give you an opportunity to place your advertising message adjacent to appropriate content. And the most important case is this, Stewart versus Rolling Stone. Rolling Stone has a gatefold, folds out, that covers the subject of independent rock bands. Camel cigarettes have attached themselves to independent rock bands as a positioning to reach young people, but only those over 18, who are interested in independent rock bands. And so they were approached and they were told by Rolling Stone, you could buy the front covers and the back page of this gatefold that folds out. So you have the advertising and then you have the gatefold in the middle, which is a recreation of what would be a college student, because remember, we are only interested in people over 18. We don't market to anyone under 18. Doodles. Spiral notebook affair. So the lawsuit is brought by the independent rock bands for right of publicity. And Rolling Stone brings a slap motion and succeeds. Two things to note. Camel cigarettes, the advertiser, is left out in the cold. So today, the I think 19th and 20th largest digital advertising agencies are Meredith and Condé Nast. You will find your marketing people are getting material that is advertising created by people who grew up in a First Amendment world as opposed to an advertising world. And the protections that the publications and the media have under the First Amendment may not cover you. Rolling Stone also got out on a slap motion, which means no discovery, which is very interesting, based on declarations that were submitted on the motion. But what the middle-level California appeals court's findings are particularly troubling in that if this is the standard, the wall between content and advertising, and the wall between editorial and sales, I'm here to tell you that as in Pyramus and Thisbe, there are some chinks in the wall. You may be able to see through that wall. And what is particularly interesting is this one. No evidence of any concern by the media that the advertisement and the feature be perceived as an integrated whole. Well, there was no discovery. So, yeah, there was no evidence, but, you know, what kind of emails do you think there are between the salespeople trying to push the content people to tell them more about what the content of the gatefold is going to be relative to their ability to convince the advertiser to participate? And many people have suggested that the horses here look like camels. It is interesting to note that Camel Cigarettes was then faced with 23 lawsuits by states' attorneys general, because once it was proclaimed that this was all an ad, Camel has settlement agreements that they can't use cartoon characters in advertising because of the Joe Camel problem. So to the extent that your companies are going to rely on the media, think again about what your need is to see what things they're coming up with respect to attaching yourselves to brand integration and content from the media, because the media may have protections that you don't have. Now, when we look at social media, we have some background we can look at, and that is the notion that going back to editorial content like the New York Magazine Best Bets column, where if the editors of a publication decide to sing the praises of your product, you are not liable for a right of publicity claim, as in the case of this Stefano versus New York Magazine, where he was a model who was featured in the editorial material and claimed it was advertising. But if you have instigated that content, if you have breached that wall, if there are emails that show that you, the brand, have participated in creating this favorable media attention, you may well be liable for a right of publicity claim, because in this case, going back to 1984, what the court said is, as long as there's no evidence of any quid pro quo, as long as there's no evidence or indication, as the court said last year in California, no evidence that the brand influenced the content, it's not advertising. But with brand integration, with all of these great opportunities that we have, what happens? We don't have a whole lot of law. My favorite one is the brilliant idea that integrating into the Lifetime TV show Love Spring for PerfectMatch.com. So you have a TV show that's about a dating matchmaking service, and they come up with a brand integration. If you'll plug us on the show, we'll pay you money. And indeed, the writers of the show came up with a joke where the head of the dating service comes back from vacation and complains to her staff that they've made 5 matches in this period of time, and the PerfectMatch.com 1,623. Now, Perfect Match is sued by its competitor for false advertising, and ultimately the ruling is that it's not advertising because they did not dictate the content, they did not dictate the copy. Their only involvement was the brand mention could not be slanderous. So this is the lesson that when your marketing people are doing a product placement and they come to you and they want you to write up this agreement to make sure that, you know, they have complete control over how your brand shows up, how it appears, and they want to dictate the copy line, this is a good reason why you should tell them they don't want to do that. It will be very difficult to negotiate that, but even if you could negotiate that, think twice about whether or not you're going to breach the wall, because then it's going to be advertising. And you all hopefully are aware that the Federal Trade Commission this last year got keenly interested in updating its endorsement guidelines to cover social media. And that means that if there is a material connection between a brand and that content, it needs to be disclosed. Now, assuming you're complying with those requirements in order to keep the FTC at bay, you're inviting a right of publicity claim, because now you've labeled it as advertising, as commercial alert, and the government would like you to, and the plaintiff's lawyer has very little trouble establishing that if there is a mention of a name or a celebrity in that content, you have to pay because you have commercialized it. And it doesn't take much to commercialize, because remember, this is an area of state law. So the plaintiff can look around for where's a good place to sue. And one good place would be Missouri. The Supreme Court of Missouri concluded that neither the courts in California nor the courts in New York have much experience with intellectual property, so it's really up to Missouri to lay down our national policy with respect to the right of publicity. And so they went on to explain that none of those other federal and state courts really knew what they were doing, and they came up with this notion that it predominantly exploits the commercial value of an individual's identity. How hard is that standard to meet? Well, the case at issue involved a claim by an enforcer from a hockey team against a graphic novel having in its comic book about the mafia an enforcer for the mafia who had the same name. Tony, the enforcer, Twist. Now, there's no similarity with respect to anything else, but due to the fact that the defendants, thinking that the claim letter they got was in defamation, decided to concoct a completely apocryphal story that this was simply coincidence and that it really wasn't defamatory because it really wasn't Tony Twist. The Missouri Supreme Court said that since you committed perjury, you have no due process rights. We are not going to in any way protect you, and proceeded to hold that having indicated that it wasn't about a comment, it wasn't about the parody, the First Amendment was waived essentially, and the sale of the comic books to hockey fans and the fact that in fact Tony Twist was the inspiration for the name was sufficient to uphold the jury award. It was also, since the court said you committed perjury, not going to consider whether or not the trial court erred in accepting the expert testimony. They hired a retired executive from the Anheuser-Busch company, this being St. Louis, who testified that sports figures receive between $15 million and $50 million for their endorsements. I would guess that everyone in this room knows that sports figures receive anywhere from a pair of sneakers to $250 million. So this was patently on its face incompetent expert testimony. The jury, faced with Tony Twist, the enforcer, not a star, who had never received anything for an endorsement, was thus duty-bound to award the minimum. And so they awarded $15 million to this hockey player for the fact that his name was used for a character and it was commercialized because they sold it to hockey fans. And that was upheld, and the company went bankrupt. So again, the wonderful opportunities you have to engender the assertion of your brand into content, what we used to call advertising in disguise, which could be as minimal as that you give something away, as in a calendar to people who make contributions. In this case, was held to be advertising in disguise, supporting a claim. The right of publicity just keeps growing and growing. What about art? How many people have sympathy for Tiger Woods, who sued over this 5,000 limited edition, 5,000, signed lithograph? Tiger Woods came into court explaining that he barely ekes out a living from selling tchotchkes and memorabilia. And he actually has a poster that he sells to his fans for $15, and this is cutting into his livelihood. All those who hold for Tiger Woods for commercial appropriation and injunction against the sale of this? Well, I maybe stacked the deck a little bit. It was a 2-to-1 decision, okay, that this is protected as art and that the artist could use Tiger Woods. But anybody notice that? What about that? So had Nike paid the artist to put the Nike logo in, how many would rule for Tiger Woods? Everybody. So the lesson here, of course, is that you want to integrate your brand into human beings, not into media, because those trademarks are there because of the people's deals with Tiger Woods. There was no deal with the artist, and there was no issue in this case about whether or not that was a violation. But where your content crosses the line from being editorial to where you sell a product off of the editorial material, as in the Abercrombie and Fitch Magalog, where they had editorial content about surfers, but then somebody had the brilliant idea of selling the same shorts as the guy in the picture, and he sued for right of publicity. You've got this problem. You've got this problem of your marketing people trying to have influence over content. And indeed, you've got a problem even where you just luck out, where you have your brand showing up. Thanks. Well, it's a lot of fun to be here to talk about my favorite subject. So we're going to, I guess, start by picking on the right of publicity as we are branching out from the introductory presentation. What I love about the right of publicity is it's one of those areas of the law that's a complete shambles. Lawyers love chaos. It's how we make our living. And it is relatively new in the law, and as a result, something that keeps expanding. So it also is grounded in privacy, which, as everybody is aware, is Congress's favorite thing to do. The one place you can get everyone in Congress all keyed up and all in together is protecting your privacy. So it's always very popular. It begins with actually 1890 Warren and Brandeis Law Review article saying that there should be some right to be left alone, some right of privacy. It gets its first formal incarnation in 1903 in New York, where after the highest court in New York said there is no private right of action or claim when you appropriate someone's image for advertising, in that case a young girl's picture being used on a flour sack. The New York State Legislature responded in shock and dismay at the failure of the common law and passed the New York Civil Rights Section 5051, which makes it a crime punishable by 6 months in jail to use a person's name, picture, or portrait for purposes of advertising or trade. And that was pretty simple because back then it was very limited and we knew what advertising was. And interestingly, relative to the lawsuit brought against Facebook last week under the New York statute, because it was a child's picture that was used, the statute requires that with respect to a minor, you must have written consent of the parent or guardian. So if you didn't notice it, there was a class action filed against Facebook on the ground that the like button uses the names of minors, and even if the minor has consented by pressing the like button, Facebook needs a written release from the parent or guardian from all of those people under the age of 18, unless Facebook wants to stick with the notion that there's no one under 18 on Facebook. Now, what also is interesting about this is that this is an ever-expanding area, great for lawyers, so that what started as name, picture, and portrait now is the use of a person's identity or persona. Photograph, image, likeness. In Indiana, where CMG, which is the Agents for the Dead, got a statute passed, they extended posthumous rights of publicity for 100 years, and it includes gesture, because if you go like this, Groucho Marx's estate will come after you. What I love about this is it just ever expands. So I write a publicity claim not for C-3PO, who Judge Kaczynski noted was being ripped off here, but for Vanna White. And I represented the advertising agency in this case. My job was to fend off the punitive damage claim, which I succeeded in doing, but ultimately this is the trial exhibit that Vanna White's lawyers presented to the jury in a 2-week trial in Los Angeles. Just as an aside, when you're trying to explain to your clients why it is that you might not rely on the American legal system, we had a jury panel of 40 people. This is 1992, pre-internet. The jury panel was under oath, and the judge asked how many people on the panel read. Los Angeles Federal Court, a jury of your peers. 3 were willing to admit to reading newspapers or magazines. Of the 37 people left on the panel, when the judge asked them under oath whether they regularly watch Wheel of Fortune, it was all 37. One gentleman pointed out, that needed to point out, that it was only because of other family members. And another gentleman stood up, and it turned out he too, in some hitherto unknown California cult, was forced by his family to regularly watch Wheel of Fortune. So that was our 2-week trial. We'll come back to that. But as I like to point out, my job was to fend off the claim for punitive damages, that this was not an intentional or willful appropriation of Vanna White, but rather a humorous notion of the successors. And in fact, we showed that Vanna White was the second letter turner. Barbara Peterson, the first letter turner, testified at trial that she taught Vanna White everything she knows. It took 20 minutes. And the jury was charged on Friday. You may recall the largest earthquake in Los Angeles in the last 100 years was the next Saturday, the next day, and when the jury emerged on Tuesday, they ruled that that was Vanna White. But I want to emphasize that in this area there is real reason to be concerned because of the possibility of punitive damages. A very famous rock group, the Sugar Hill Gang, was appropriated by Snapple in an advertising message. They had actually participated in this concert that Snapple sponsored, and Snapple put together this little promotion, including Wendy, the Snapple lady, with the Sugar Hill Gang. And the judge, the court, awarded $2.8 million in punitive damages for the intentional use where their actual damages were $200,000. The claims in right of publicity are things that your companies need to be very sensitive to. In this case, a model who posed for a photograph discovered that without paying him for the extended use of the photograph, his photograph had showed up on the labels for Nescafé. And the jury was persuaded, as could happen at any trial, to award a small percentage of Nestle's profits for the period that it used his image, which resulted in a $15.6 million jury verdict for the use of an actor's photograph beyond the scope of the license. I do need to point out that that was reversed, the appellate court concluding that Nestle probably wouldn't be stupid enough to have a blank label, and so it wasn't the question of what's the value of the label. El Exigente might have been good on the label. It was a question of how much was that particular person's image valuable as opposed to someone else. So for ordinary models, the damages may not be the same as they are for celebrities. The other thing about the right of publicity is that it falls also in under the Lanham Act, and that grows out of a case of mine in which Woody Allen brought a lawsuit for right of publicity, and we persuaded the judge that in the context of this ad, it was clear that the communication was that that's not Woody Allen. That's actually my client, Phil Boroff, who is an actor. Unfortunately, when Phil, who was hired as a lookalike, you get the joke, she's swooning in recognition because of the card, not because he's a celebrity. They didn't think he looked enough like Woody Allen, so that's Woody Allen. And his name in the ad on the Annie Hall videocassette box in order to reinforce the notion that Phil just didn't look enough like Woody Allen. Now, that falls within the artist's exception to the right of publicity. You can, in selling an artist's works, use the artist's name and picture. So I got rid of that claim. The judge looked at Woody and looked at Phil and concluded that nobody would mistake him and got rid of the right of publicity claim. He also brought a copyright claim, but we had an interesting discussion as to whether his character is a schlemiel or a schlemazel, but in any event, it goes back to the Yiddish theater and Charlie Chaplin. And the federal district judge in New York understood what I was talking about and dismissed that. But just as I had gotten rid of all the claims in the complaint and was trying to get out of the court, the judge said, isn't this a lot like co-op advertising, where a manufacturer provides money to a retailer to support the advertising? And wouldn't there be a possible claim here that Woody Allen seems to be endorsing national video? It's one of those great instances where plaintiff's lawyer says, no. Yes, Your Honor, we were going to brief that. A claim not in the complaint. And so the judge invented the claim which takes on a life of its own, because in the Vanna White case, the jury awarded Vanna White only $150,000 on her right of publicity. They awarded more on her Lanham Act claim, which was based on endorsement under the old statute. In 1988, the Lanham Act was amended, and now the claim for likelihood of confusion as to the nature of the association accompanies all right of publicity claims and is in many cases even more potent, as we will see, when you look at how little you need to establish to withstand a motion to dismiss the federal Lanham Act claim 43A1A of the federal Lanham Act, likelihood of confusion as to what that association is. So in conjuring up popular culture and doing all of the things that we do in marketing, there is this problem. And with these kinds of likelihood of confusion claims, we come back to our old friend punitive damages. So Tom Waits, in a sound-alike case, has a $75,000 price tag if you wanted to hire him for a sound-alike, but a $2 million punitive damages based upon communication between the ad agency and its lawyers, where the lawyers said you can't do that, and they did it anyway. And where that brings us today is that even in those jurisdictions where a right of publicity claim may not succeed, a case brought by the Naked Cowboy over the fact that the M&M company's billboard in Times Square picks on popular cultural icons, resulting in, this is the case of the Naked Cowboy versus the blue M&M. Judge Denny Chin, who has just been elevated to the Second Circuit and is, in my view, an excellent judge in the intellectual property realm, who you will hear more about, basically said, this is not California. We know the difference between a piece of candy and a person. And I am not following the Vanna White decision, but I can't dismiss the Lanham Act claim because who's to say what people today think about brand integration and whether or not you have to have the celebrity's permission when you reference and when you deal with popular culture. I can't dismiss it. He kind of wanted to dismiss it, as you can tell, but it's really hard to answer that question today as to where we are. Today the question is, what is commercial? You all recognize Lindsay Lohan? Well, it turns out that when you have a commercial in which you are describing a milkaholic infant whose name is Lindsay, you have a problem when the complaint reads, I am the most famous substance abuser with the name Lindsay, therefore you have appropriated my persona. So there's just no limit to where these claims can go once you cross the line into being commercial. And therein lies our biggest problem as to when do we cross that line in today's world, where everything we do in terms of marketing is about how to get a strategic brand message before the consumer in anything that doesn't smack of advertising. And so every effort is made to have our marketing people reach down and ultimately move beyond the various commercialized content to social media. Where is that line? Well, the principal advice I would give to you, as I give to all my clients, is of course not to do business in California. But assuming your company has a problem following that very sage advice, understand that in California, the California Supreme Court, faced with a false advertising claim against Nike based on its public relations effort to defend its labor practices in Asia, concluded that any communication by a company that sells products is likely to be viewed as commercial. So the brand involvement in the content that goes out is a ripe area for write-up publicity claims. Now, I've been running around the country warning people about this for a couple of years now, but the class action against the Facebook like button is what I've been warning, and we will see where that goes. But as your brands take advantage of reaching consumers, understand that you are going to be exposed. There is out there many do-gooder public interest groups like Commercial Alert that have been proselytizing and going after all of the ways in which brands operate with the requirement that that content be labeled as advertising. They petitioned the FCC. So far, we do not have in the James Bond movie a bold, super appearing on-screen BMW paid James Bond to ditch the Aston Martin. But you all know that that did cost $60 million to get him out of that Aston Martin. And they have petitioned the FTC similarly. And we have seen, in response to this, a steady movement toward their obligations to label the advertising influence, starting with the program format, the infomercials, the programming that looks like it's content but is in fact advertising. The point being that once you have made that transition, once you've done something that is advertising, you are in the realm of a right of publicity claim as well as compliance with advertising. And because can you then use that for advertising with all those people in the background? My answer is no. The problem you have is that the PR people grew up in a world where their content was mediated through the media's First Amendment protection. So they never bothered to think about whether or not there was a problem, because he who supplies a First Amendment publisher usually can be wrapped in the First Amendment and nobody would know. But today, your press releases are not mediated through the media. They're put up on your website. And so the kinds of things that PR people just inherently do to try to create attention become advertising. So whether this was a good PR release or not, whether anybody in the media picked up on the Mach 1, whether this was a good hook, it was a good enough claim for Chuck Yeager to sue for right of publicity based on simply putting the press release up on the website. The FCC has nailed video news releases that PR people create as requiring disclosure by broadcasters. And the quid pro quos go on. So when the media decide to cover things in terms of style, okay, there isn't a right of publicity claim. But how many people believe that the letters that are sent in, where can I find the jacket that the guy on Fringe wears, all come from disinterested consumers as opposed to PR people? If they catch you, you'll be liable. What more can I say? So when the media wants to feature something and they do it, they're protected by the First Amendment. But if you are providing the media with swag or inducements, you've got a right of publicity problem. And today, we've got the media telling us that we can do sponsored stories. The ethical divide between editorial and content. In the 21st century, we've got people online saying it's no longer relevant. Well, if you're doing a sponsored story about celebrities, you better clear the rights, because a sponsored story is not going to be non-commercial. When you do the manufacturing of the news, the content for selling, understand that the media that offers that to you may be protected by the First Amendment, but you're not. When your marketing people see all of these various exploitations by the media and say, oh, cool, we could do that, note that responsible publishers are clearing all of this material because it's advertising, something that is constantly overlooked when I am inundated with, why can't we do that? Why can't we do that? You know, we'll sponsor the charity event and we'll advertise. Well, responsible publishers are clearing it, so the wall is going to be what confronts you. And when you get to your own corporate website and you're by the people who make websites and saying you need content, you need lifestyle, you need to have the media coverage, you need to be thinking about the right of publicity. Because you may sponsor something, you may organize something, but when you put it up on your website, you got releases from all these people? Because if that content is promoting your brand, is it advertising? Now, a branded website has been held to have both editorial content and marketing. Interestingly, it's Judge Chin again, who ruled in this case, which was affirmed by the Second Circuit, that even though your website has places where people can buy things, if you keep separately the editorial material and you keep that wall up, then again, assuming there's no quid pro quo, assuming you don't breach the wall, you may be okay. But always keep in mind that little comment about there was no evidence that there was any concern by anyone on the editorial side that the wall had been breached. Oh, I don't want to see the emails. And the fact that people will, on their in the news column, include things that they have either placed in the media or that the media cover. So, you know, Jordache can talk about the fact that People magazine may have covered them. But when you blow up the cover of the magazine, when you go beyond the thumbnail, you've got paparazzi photographs that are copyrighted, and you've got celebrities who you are now incorporating into your advertising. And you know, I'm inundated with examples of these, but usually I can convince the client that the examples they come up with are companies that are judgment-proof. There's a fundamental principle of intellectual property. That which a judgment-proof college student does is fair use. That which a corporation with an address and a bank account does is not. Facebook. So you have a Facebook page, you have a MySpace page, and you rely on their terms of use, and you rely on the consents they have. Whose picture is that? This person is not a fan. This is somebody's avatar. Hopefully, you know, mom put the picture of the kid up, but you still don't have written permission to include a child in your marketing materials, because what is your Facebook page? And the terms of use that protect Facebook and Twitter and the CDA and the DMCA, you know, are you an ISP when you are doing a Facebook page? And isn't Facebook okay? And what your marketing people are being inundated with is all kinds of opportunities on your website to include paparazzi photographs and to tie the celebrities into marketing your products. Indeed, there's this one group that I really love, Pixasa, that has the software for tagging images in a picture so that you can reference them. and have suggested that you certainly could appropriate celebrities to advertise your products because, after all, it's non-invasive editorial content. Jennifer Aniston, used as the model to sell your sunglasses, is non-invasive editorial content. Try that on a California jury. These folks, unlike the Taster's Choice, can show damages when you've appropriated celebrity content. And what are you doing now? You're opening up your world to these non-existent 13 to 18-year-olds who do not populate the internet. Because the user-generated content that you invite may well be held to be your advertising when you put it up on your website. The buzz marketing people who you hire are very likely to be unschooled in the kinds of protections and regulations that you need. Let's understand, last week Facebook was grossly embarrassed when Burson Marsteller, the largest PR company owned by WPP, participated in astroturfing. That's fake grassroots. That is that Burson Marsteller, hired by Facebook, would you please, trash Google on the internet, was outed by a blogger who published on the internet the emails between Burson Marsteller saying, we would like you to say all these untrue, false things about Google, and we can't tell you who our client is. So people are still getting this wrong. Now, Walmart and Edelman were the first ones when this first happened. And you would have thought Walmart knew something about marketing, and you would have thought Edelman, the largest private public relations company, would know something. And maybe in their defense, it was the beginning of the internet, and they didn't know. But they were nailed for astroturfing. So what's Twitter about? Well, when your marketing people decide to use your people to use Twitter to say nice things about the product, that's not legal. Word of mouth advertising, impersonating or not disclosing the connection, no, sorry. FTC says bloggers need to disclose the material connections. You need to disclose if people are being given anything of significant value to say nice things about your product. That makes you responsible for that blogger. And when that blogger decides to talk about their friends and use their names, you've got to write a publicity problem because it's advertising. You've got a huge problem about how you disclose material connection in today's social media. The FTC, on the endorsement guidelines, did research and concluded that this disclosure in the middle of the page in red was inadequate. So for all of us relying on disclosures, that one on the bottom is what you'll get out of your marketing people if you really try. That's our classic 10-point type, black on white. And I'm sure you've had the same experience as I, that usually the only place they can put the disclosure is on the variegated background. I mean, I had a car rental client, and for some reason, whenever it came time for the disclosures, it was a cobblestone street. But your obligation to inform the bloggers about what they have to disclose is a huge problem. And then when they make that disclosure and it all becomes advertising, you've got to write a publicity problem. So you may want to stop off at the comply desk outside and look at what you can do about disclosing these connections and how you can comply with what the FTC requires in terms of disclosing material connection. But also keep in mind that you have liability with respect to the social media, with respect to the bloggers, and with what they say. And the right of publicity. Facebook having a class action last week on the like button. going to inspire a lot more of this same exposure, and the media and the people who you are relying upon to create your materials may have defenses that you don't have. So like Camel cigarettes, the media who induced you into doing this are protected, and you're left holding the bag. So you're going to have to really be looking at what's being done, and once you get to the compliance with the disclosure, to think about the problem of the right of publicity, because social media is about people. It's about your friends. It's about using names. And it's used by this non-existent group of people between the age of 13 and 18 that nobody on the internet seems to know exists.